For around 4 decades, the Supreme Court has considered some form of affirmative action to be permissible. What does this mean? It means that the color of your skin can be factored into the university admissions process. This precedent was established through cases such as Grutter versus Bollinger. Proponents of affirmative action range from those who say they want to equal the playing field based on a long history of systemic racial discrimination, to those who take a more radical approach, closely tied with critical race theory.
I mean, from a philosophical standpoint, the demands of justice are not clear there, because who was harmed, who did the harming, who bears responsibility for that harm are all complicated questions. And they're questions that are worth talking about. But in the last 5 years, certainly, critical race theory has simply declared it's a trump card, and therefore the only possible answer is that the demands of justice must be fulfilled in this particular way by meeting whatever the demands are of the person espousing the critical race theory.
In this podcast, I sat down with Ryan Yonk to discuss the Supreme Court's latest challenge on this matter. An activist group called Students for Fair Admissions are taking on Harvard University, claiming that racial classifications and preferences in college admissions are unfair, unnecessary, and unconstitutional.
I want to see affirmative action being repealed and become illegal in college admission system across this country.
We cannot have holistic admissions without race, because race is embedded into every single facet of everyday life for people that come from diverse backgrounds.
Ryan is senior research faculty at AIER. His research explores how policy can be better crafted to achieve greater individual autonomy and prosperity. We discuss the hotly debated affirmative action case, some history of affirmative action and how it came to be, and what happened to judging a person on the content of their character versus the color of their skin.
So if you have a problem figuring out whether you're for me or Trump, and you ain't black.
And at its core, it really brings a primary issue to the court that asks the question, is under its previous decisions, is Harvard's approach to affirmative action allowable given both the larger constitutional issues and the structure that the court had set up in Bollinger and in Bakke? And essentially, the plaintiffs are arguing that Bollinger should be overturned, and that we should return to the arguments in Bakke that suggest fairly strongly that race can essentially be no more than a small part of an overall decision making in admissions, and that's in part that's what Bollinger also was deciding, was at what role can race play in the enrollment and admissions decisions of universities.
Yeah, so I was looking back in that case a little bit, and it was a really hard decision for the justice to make at that time, because they realized that affirmative action, if you look at the total sum, might actually be harming some people. And so there's a balance to be made there. And I know that it took them a lot of time to make the decision.
Yeah, so the court took them time. It also took multiple decisions. So we did not end up with a single majority opinion across all of the issues presented in Bollinger. What we ended up with was a plurality decision where enough votes were able to be picked up on specific issues to arrive at a decision that allowed for race to play a partial role in the admissions process, but quotas, which had been at issue, were disallowed in their entirety. Okay. Essentially, race could be one component of an otherwise holistic admissions program, and sort of firm rules about how many, what percentage were disallowed under the Bollinger decision. Okay. And there were a total of 6 separate opinions written by the justices, which indicates not a lot of agreement on either the factual interpretation or the theory of law that should be applied. And I think what's most interesting is the proponents clearly believe that the current court is more likely to arrive on a single theory of law, at least enough of the court will, to get a majority opinion that clarifies what approach should be taken to understanding the role of race in college admissions.
So why did they expect to have more of a majority position on this now? So
the makeup of the court has changed quite a lot. In part, you've seen some retirements. You've also seen the replacements have a are more likely. I would agree with them that they're more likely to articulate a consistent view. We're also now a number of decades on from the initial affirmative action decision in Bakke, which was where this all gets started in.
What year?
It was in the late 70s, 1978, I'm pretty sure. And that case really set the tone for how affirmative action discussions would go, in part because Bakke essentially pushed back pretty strongly against race-based admissions decisions and instead articulated an approach for how you could consider race in admissions, but it could not be the determining factor. And that's really at the core what most of the arguments about affirmative action have become, is what role and to what extent is race allowed to be considered in the decision-making process for university admissions.
And so do you think that they have a good case? Like, has Harvard been going outside of its domain if you compare to what those previous cases?
So the proponents are clearly believe so. And the trial courts have been somewhat split on the facts of the case. But where we're at now is that the court in Bollinger left open its interpretation of how the law should be applied. Because they couldn't arrive at a single decision, there was not a particularly clear test that was articulated for how to know. And so you have various interpretations of the Bollinger decision that have been applied by different schools in order to try to reconcile their own admissions process with that. And I think that that's really at the core. And that's what I expect we're likely to get from the court in this decision, is an articulation of what the proper test is. Now, I think the proponents are hoping for a sort of straight up 14th Amendment style, race may not be used there. It's always risky to prognosticate about what the court will do. My guess is the court is not going to end up there exactly, but instead we'll see a refining of the test. And whether or not Harvard falls within or without that, I don't know. Yeah. But I suspect we're going to get a revision to the Bollinger test out of the court. So not out of the realm of possibilities that it's a complete 14th Amendment argument, but I think it's unlikely.
Right. Are Harvard using quotas now? In order to... So
quotas are not allowed at all. So that part of Bakke never went away. That exact quotas are not allowed. The question comes in, how is race brought into the admissions process? And to be fair to those that argue for affirmative action, there is some fairly clear evidence that many of the so-called objective measures of admissions potential fail to capture the overall potential of a candidate. So these are things like the SAT, the ACT, if those sort of testing are reflective primarily on what things the student has learned already. Mm-hmm. And what admissions are trying to do is figure out how to place bets on how well the student will do in school. And so one of the arguments for affirmative action is that given the state of education in the United States, those from particular, especially socioeconomic, but also racial backgrounds, because the two overlap. And that's one of the problems in affirmative action, is you end up using one as the proxy for the other, which is not at all helpful. Are less likely to have had the same sort of opportunities, and therefore those objective measures are not as good a predictors about their future success as we might hope they would be. And so they're interested in providing those opportunities. That's sort of the most charitable version of what affirmative action is trying to do. Mm-hmm. There are others that would articulate that instead the goal of affirmative action is to get universities to mirror the overall population. Right. And that, I think, is at the root of what Harvard's position was, is that they're trying to make universities more representative of the community at large. And this has been the argument that's been going on in higher ed admissions since the mid-1970s.
And can you expand on that a little bit? Like, why is that more extreme?
Yeah, so one of the arguments is, so if you listen to a lot of folks that work in higher ed, especially the admission side, there are three distinct visions of what a university should look like. There is one version that a university should mirror the place in which it exists. And so you should be looking for a student body that matches the people that are in what they call its catchment area,
Right.
the area that the university is designed to serve. So, for example, if you're looking at Utah State University in Utah, I use this because I know it pretty well. You're looking at a catchment area that covers Utah and some of the surrounding edges of the states, and so that version would argue that you should be looking for a student body that is reflective of that catchment area and is serving that area very particular. So that's the first version. The second version is that a university should reflect its applicant pool, so that you should be able to identify that based on the applicant pool demographically, the student body that enrolls looks a lot like the applicant pool. That you assume there's some normal distributions in in people that apply from different demographics. And if you're selecting the best regardless, you should get a mirror of that applicant pool. In the last about 20 years, although there are roots of it far before, there's become a notion that universities should mirror nationwide demographic trends. And if you listen closely to many of the proponents of affirmative action, this is in large part what they're arguing for, that a university should look like the United States overall. And as a result, that means that you're pushing for universities that may not have widespread diversity in their catchment area, whose applicants pools may not be reflective of the larger social sort of makeup, to then try to match who they accept in order to construct something that resembles. And many of the affirmative action sort of programs are undertaken in an attempt to do that, to get the university to look more like the nation overall.
So I'm thinking of Martin Luther King Jr., of course, who said, judge a person by the content of his character, not the color of his skin. But then you have affirmative action that starts to play out in the late 70s, as you're saying. So what happened there? How did we go from that to then?
Well, so in large part, it has to do with how we think about the modern discussion of race. And there's a couple of things I think that are important at the outset to say. One of which is that university admissions had for decades, going into the 1970s, and then it persisted after, been one of the bastions of racial discrimination. It's not as though this was a place that was absent the sort of Jim Crow understanding of the 1960s. In fact, many state universities were segregated up until the end of Jim Crow. And so you had real barriers that existed, and we should be cognizant of that. And again, taking the most charitable interpretation, many, I think, of the early affirmative action arguments were that we needed to tear down those barriers and provide affirmative action to allow people to then get into the pipeline. What morphed in the late 1990s, in particular, with the rise of critical race theory in the legal profession, was this notion that somehow affirmative action wasn't about removing barriers and allowing for achievement, and instead it was about some moral obligation to create a match of what the overall society looks like, regardless of whether or not there were barriers that were there. And so suddenly now it's an outcome-driven approach as opposed to trying to fix the input side. Early affirmative action was primarily focused on how do we eliminate the barriers. And one way to do that is to say, you can't continue to discriminate. We should be expecting to see some folks coming in that don't look like everybody else. Absent that, there may be a problem.
So it was more kind of in broad terms, like an equality of opportunity versus equality of outcome, and it morphed into...
And then over time it changed. Now, there were early folks that were arguing much more in the CRT vein that we see today. But again, I think it starts with this sort of discussion, that there is a problem, and what is the way in which we actually go about addressing it. I've heard some talk about affirmative action as though it has no noble roots. I think that's a misnomer. I think it's a problem if we look at it simply and say either there was no real issue here or there's no way to address the issue. I don't think that's quite right. But I also am increasingly convinced that as time has run, we've now started to try to construct what we think the outcome should be. And that's not a whole lot better.
Why?
Well, because I mean, it's so. I'm an economist. I'm a big fan of Friedrich Hayek. As soon as you start to try to plan the order, that order begins to be unwieldy, and we start to see some fairly strange outcomes. For example, we see things where the university's mission starts to drift, or the expectations start to change in response to this goal of matching something out there, or sometimes it's referred to as increasing diversity. But fundamentally, what they're looking for is trying to match that population or exceed it on the farthest extremes.
Right.
And in doing that, we lose a whole bunch of other things. Much like the central planner can't know what the results of their plan will be, the results of the university central planner in admissions face a similar challenge.
Yes, that really makes sense to me from a philosophical perspective. One of the things that I saw as well with this case is that they're arguing now that what's happening because just to make it clear for our audience, the students for fair admission who are arguing against Harvard on the affirmative action front, they are mainly made up of Asians.
Correct.
And they're saying that basically white people and Asians are being disfavored.
Correct.
And Black people and Hispanics are being favored.
Correct.
But what they found there too was that they also have something which is a personal rating score to get them in. So you have your academic achievements, your extracurriculars, and then you have this kind of score as well, your personal score.
Yes.
And the plaintiffs are arguing that the personal score of the Asians has been lower than everybody else. So
so this is where does the question about how is a race allowed to be brought into the admission process really course? And that's among the central issue. And so as the personal score is designed to be two major things, incredibly nebulous and subjective based on the person doing the review.
Yes.
And that's really what Harvard has done in its attempt to make it not a capricious approach, but an approach that brings in some of these things that the court has clearly left open the possibility that it might be considered. But Harvard is using it in this particular mechanism.
So they're kind of using it as a way to extend the affirmative action.
That's what the plaintiffs are absolutely arguing.
Right.
Harvard's response is that's not what's going on.
Right.
The statistics don't seem to bear Harvard's position out. And what I think the court's actually going to be addressing is whether or not the finding of facts are over in the case. Now we're at questions of law. And so fundamentally, the question is going to be what is permissible in terms of the decision making, and did the lower courts decide the case correctly? And fundamentally, what students for fair admissions wanted was a determination that this question of race should be excluded entirely from the admissions process, that essentially you should have race neutral admissions.
So you don't think that it will quite go that way though?
I think it's unlikely we will get there. There's a good chance you're listening to this after the court has ruled. But let me walk us through a little bit sort of what could lead us down the couple of different paths.
Yeah, sure.
So the path I think that the plaintiffs are hoping for is a path that essentially says this is a 14th Amendment question fundamentally, and that the courts have erred in allowing for the use of race as a determinant factor in these admissions process. That's pretty clearly what they want. There's probably at least two justices that would endorse that perspective. Nothing is ever certain, but it certainly from their previous jurisprudence would seem to indicate. We have some new justices on the court that it's not clear how they'll rule. And we have one justice that has recused herself from the decision in the case. So we're likely to get a split decision, but that's one path it could take, is that standard 14th Amendment. I can't count to 5 to get us to that. It's not impossible. Because remember, your magic is you got to get to 5 votes on the Supreme Court.
Yeah.
Even with a justice recusing themselves, to make any substantive change, you have to get to 5. If it splits 4-4, the lower court's ruling holds, and it tends not to be viewed as having precedential value because you don't know how a full court would decide.
Why did that judge recuse themselves?
They were involved in the process. They had been connected to the case previously.
Okay.
Wasn't mandatory. There is no requirement that Supreme Court justices recuse themselves. It is tradition that cases in which a judge has a distinct connection to one of the plaintiffs or the earlier process, they will step out and not be involved.
Okay.
So that's the first sort of what the plaintiffs want, essentially. The second would be the other extreme, which is you could see a judicial outcome that would argue that race is an appropriate thing to be used, and essentially would return us to the allowance of just standard affirmative action. There's only 3 possible votes that would go that way at the moment, and I'm only convinced that 2 of them would vote that way. So I don't think that's a likely outcome, although it's one of the possibilities.
And what would it actually mean in application?
It would mean that that you would have far more ability to use race in the decision process.
So you could potentially use quotas and things like that as well?
That is one of the legal possibilities. Highly unlikely. I don't think the court goes there.
Okay.
In part because it's not the issues in front of the court. The court doesn't have to restrain itself to the issues in front of it, but I don't think they'll go there.
Okay.
What I think is likely emerging, and this is I would expect this is where the court comes down. And in fact, what I think the most likely outcome is, and that is a clarification under Bollinger, because of the split decisions. What the boundaries are on the use of race and how race can be brought into the process are decidedly unclear. It was essentially left open. There was a case in Texas for a while that looked like it might give us some of the answers, and then Texas changed their entire admissions process by essentially hardwiring Texas residents into their admissions process. So it lost a bunch of the precedential potential because of the change that Texas made. And so the clarification, I suspect, that is most likely in this scenario is a far stricter test about what is allowed to be used and under what circumstances race can be used in the process. In function, that would mean it would be far harder for programs like Harvard's to simply use the gray area and use race in that way. My suspicion is that it will look something more, the test will look something more like it can be one of many potential approaches, just like extracurriculars become part of the overall thing, just like other things. And the court has in the past shown some willingness to acknowledge this as a possibility. And so my suspicion is that we're going to get a revision of Bollinger. And that revision will likely provide more clarity, but will be a more conservative is not the word I like to use in these scenarios, but that I think is how it will be billed in the media, a more conservative approach to the use of race in college admissions. On balance, I think that's probably a good thing, particularly if we remove some of the gray area in the test.
So you think that this will restrain what Harvard is already doing?
I don't know if it will restrain Harvard's plan exactly. The question will be how the court sets up the test. And this is actually, we often think about Supreme Court cases as being primarily about the case itself in front of them. That's in U.S. sort of jurisprudence, that's important to the plaintiffs involved. Fundamentally, the larger questions of law and how the court approaches the questions that are placed before it in the particular case end up being far more important over the long run. And so whether or not Harvard's particularized program is struck down or held up matters a great deal to Harvard, obviously, and to the fair admissions plaintiff. How the court arrives at that decision and what the court articulates as how people should think about the law will end up being, I think, far more important over the law.
So that will be kind of setting the precedent. That's what they're more focused on.
Yeah. So the court is making the decision in this case, and they're going to make the decision in this case based on the law primarily, and then they'll apply the law to the facts. Although That was done by the trier, a fact below them. And fundamentally, they're going to be setting precedents. They're going to be asking the question, was the law correctly applied? Was the constitutional principles correctly applied? Is there some clarification that we need to give about how to apply these things? And they do that typically through their majority opinions and the minority opinions. The majority opinions have more weight, obviously.
So why do you think that Sandra Day O'Connor, that was the name of the judge who ruled on the previous case, the Grutter Bollinger case?
Yeah, the Bollinger case.
Why do you think that she kept it open-ended?
So you have to know if you know a little bit about who O'Connor is. O'Connor wrote the decision that ended up being able to get enough votes to actually decide the case. She was a right centrist on the court. Mm-hmm. She was fundamentally interested in the questions, was able to put together an opinion that could garner enough support to articulate at least some vision of what race could look like in college admissions. Because I think one of the realities in the time period that Bollinger was being decided was that we were not going to see race just eliminated from college admissions. That I don't think was a reasonable possibility. I think that there was increasing sort of push for college admissions to take into account the totality of circumstance. And that's an important idea. Mm-hmm. And so they were sort of grappling with how do you articulate what is and is not allowed. And as we saw, there were 6 opinions in that case, and they only were able to come to a conclusion on the issues and with limited precedential value in terms of the direction that it gave people. And so O'Connor is sort of that right centrist judge that's able to do that. The true centrist in that era was Anthony Kennedy. He was not going to be the one to be able to write that opinion. O'Connor was far more likely.
Why couldn't he do it?
Because Anthony Kennedy voted on the Supreme Court a little like he had a bit of a split personality and voted all over the place. And was not going to be able to create a nuanced enough opinion to garner support.
So affirmative action, if we can just look back a little bit on the history of that thing itself, where does it come from, the idea?
Well, so the idea comes from recognition of that there were structural impediments typically created by government based on groupings of people by race, by religion, by all those things. And affirmative action is the notion that you may need to take affirmative steps, positive steps, in order to break down those barriers, to place people back on an equal playing field. That's the root of it. It's a notion that's been around since the end of at least the Civil War. Goes back even a little bit before that with other groups. And it's a recognition that those structural impediments created by government are real, and it's one of the ways in which we grapple with how do we deal with government created inequality. And affirmative action is meant to try to overcome that.
Right. Or at least it was in its roots, perhaps.
It's still meant to do that now. It's just now has expanded what those impediments can be counted as to try to do that.
Well, I think of it kind of, just giving a basic example of women's rights.
Yeah.
Right. That was the idea, was rights should be equal for women, yada, yada. And then it turns out that now that has kind of morphed into second, third, maybe even fourth wave of feminism now. And so it kind of changed from that idea of being on the same playing field.
Yeah.
Like, do you think that the same thing is happening here with affirmative action?
No, I think that's a reasonable description. You can sort of imagine things like affirmative action proceeding in sort of 4 phases. You have the initial phase, which is the elimination of de jure requirements that treat people differently. Meaning, by the law, is there a difference in how people are treated? So that's the first step. The second step is, if we know that this is how they've been treated in the past, how do we either provide reparations directly to the people that were affected by this different treatment in the form of opportunities, in the form of training, those things. So that's the second approach. These are first order people that were directly affected by the action.
Right.
And then we move into what I would call the third phase of affirmative action, which is we know that there was this earlier phase where there were legal differences, and we know there was a need, even in phase 2, potentially to make payment for the damage done to that individual. The third phase begins to say that damage is multi-generational, and it crosses time, and therefore we should have policies that are designed to continue to help folks that had been previously disadvantaged catch up.
Mm-hmm.
And that's really where the current state of affirmative action law exists, is at that third phase.
Right.
There's a fourth phase that's emerged in sort of the last 20 years or so, and emerges in large part from critical theory in legal circles. And that is that there is, in fact, we're not talking just about the legal, but there are these social structures that were never addressed back here that we now must address and make recompense for. And in order to overcome those things, we have to do, the laundry list is enormous. And you can track down Phil Magnus, who can tell you all about the laundry list under CRT. But fundamentally, it's sort of that 4-stage approach. And what I think is you have some places that are wanting to do affirmative action at the stage 4 that I talked about, but the legal side is still primarily down here at most at stage 3. And much of it is dealing with, okay, what are the boundaries of that stage where we see long run effects from this earlier problems? What do we do about it?
Right, right. Can you just briefly explain critical theory or critical race theory? I mean, they're two different things.
There is no short answer to what critical race theory is. And in function, the terms in policy discussions get used interchangeably. Critical race theory is a legal theory, and it's a notion that race is the primary determinant in how individuals interact with the social function, including the law.
Mm-hmm.
And that as you look at how the law interacts with individuals, race must be a primary concern in it. And from that, we've seen the emergence of a whole host of other things that escaped the sort of walls of the law schools and entered into a much broader conversation.
Right. And
as a result, those conversations now have placed race right back into the center of what every discussion must be.
Yes.
It very quickly becomes race all the way down.
Right.
One of the interesting things is I ended up in a very strange discussion at a conference I was at some time ago, where we were talking about mental health in particular. And one of the points that I suggested was that race was one of many things that matters to how mental health services, how your access to mental health services is affected.
Mm-hmm.
Certainly, you can see the racial disparity. And the argument I got into with a very earnest person was that they pushed back hard and said that race was the primary determinant. And that's sort of emblematic of how the discussion in critical race theory goes.
Right.
There are those that push back, I think, wrongfully on the idea that race doesn't matter at all. I think that's a misnomer when we talk about critical race theory. Race does matter. It has lots of connections to other socioeconomic status. We can see some of the long run, but it's the notion that somehow it's the prime and only thing that we should be talking about.
Yeah.
There are lots of other things that are important.
So I'm just going to read something that Edward Bloom, who's the lawyer against Harvard, said. He said, you cannot remedy past discrimination with present discrimination. And he basically argues that he said something about being colorblind as well.
Yeah.
And, I mean, that's something that I certainly believe in, being colorblind. So, but I do understand as well how race matters. And to some people, right, it's kind of a very subjective experience. But are you arguing that it's also an institutional experience for people?
Yeah, I think it would be wrong to suggest that it's not at all an institutional thing.
Right.
I think those that are arguing for sort of the most extreme versions of critical race theory overstate the case. And certainly Bloom's argument there is the argument they've put forth. This is the race neutral admissions goal. It's the same argument that's been made in virtually every affirmative action case opposing affirmative action. It sounds really good, and I would really love that that was the world we lived in, was where we could simply arrive at that.
Yeah.
We need to be cognizant that that race still has an effect. And absent us being cognizant of that, it becomes very easy to get sucked into the trap of people pointing out distinct differences in how people of different races gets treated, and thereby get tagged with the idea that racism doesn't exist. And that's, I think, oftentimes what folks like Bloom will get accused of making the argument. I don't think that's his argument.
Right.
His argument is that there's a constitutional principle here that says you cannot solve one past discrimination with future discrimination.
Right.
But that's fundamentally a legal argument.
Right.
And there's a broader argument that is sort of important in the discussion. And I'd love us to be in a place where we could do that tomorrow.
But
I don't know how we get there from here exactly.
Yeah. I mean, they're complicated questions,
Right.
and I think it comes down to as well the history of America and the legacy of racism and slavery and all of those things. It's really hard to kind of to separate all of that and just say, let's just kind of move forward without focusing on race. But as somebody not being born in America, when I look at that, I think that there is so much focus on race, whether it's, fighting for kind of level 1 affirmative action or all the way up to critical race theory. And I mean, I wonder if that does kind of exacerbate the problem.
Certainly, I think that's the case, especially when you move beyond the direct. So it's very difficult to find anybody that would argue against the level 1 stuff. And oftentimes it's difficult to find people that would argue against level 2. When you can identify someone who has been specifically harmed, most people, the vast majority, would acknowledge there should be recompense for that. It's when you get to 3 and 4 that we start to have real questions about what are the demands of justice here? And they're not clear. I mean, from a philosophical standpoint, the demands of justice are not clear there. Because who was harmed, who did the harming, who bears responsibility for that harm are all complicated questions.
Yeah.
And they're questions that are worth talking about. But in the last 5 years, certainly, critical race theory has simply declared it's a trump card. And therefore, the only possible answer is that the demands of justice must be fulfilled in this particular way by meeting whatever the demands are of the person espousing the critical race theory.
Right.
This has emerged in the work that surrounds the 1619 Project. I'm a big fan of the idea of having people understand what 1619 was. That's not what that project became. That project became a political agenda, and an agenda that was designed to make a particular argument.
Right.
By the same token, people ought to know about the Tulsa race massacre. That's the sort of thing that ought to be well taught, but it should be taught as a historical narrative, in fact, and as a warning about what happens if we allow sort of people's worst angels to overtake them, not as a justification for some large-scale political agenda about what we must be today.
So do you think then that things like the 1619 Project, in some of their distortions, exist because that history was kind of ignored? There were certain parts of history that were ignored,
So I live in this really weird world where I had one of the best possible historical sort of trainings through my high school career. I was taught history by Margaret Obrey, who was an exceptional teacher. So people would talk about the fact that they'd never heard of the Tulsa Race Massacre. And I'm like, how have you never been taught this? I mean, this was something that we dealt with in her history class as part of the larger narrative of the Jim Crow era. And so I'm left a little bit flummoxed at times because I was taught a pretty sort of eyes wide open version of history by Margie. from that, I think we have seen places where there has been a sugarcoating of American history. In my own classes, so I teach what I call American Thought and Culture class. And part of what we do is we look at some of those things. We look at issues that surround race. We look at issues that surround progressivism and communism, and we try to look at them eyes wide open to learn from them rather than a specific agenda that says, I can use this to get what I want today.
Right.
And that, I think, is at the core of many of the problems of things like the 1619 Project. Not the idea that we should know a lot, we should know about what went on in that period,
Right.
but it's that there's some predetermined outcome that we then use those things to justify.
Right. And do you see any kind of connection there as well between that agenda of the 1619 Project, which is pretty much an anti-capitalist agenda, right? Meaning like we need to kind of repent for the sins of the past by abolishing our current system?
1619 is this wonderfully strange merging of critical race theory and Marxism. It's a very interesting combination. From an academic view, it's fascinating to watch. It's terrifying from sort of if this is the new version of history that will be taught to folks. It's not an eyes wide open version.
So you don't think that critical race theory and Marxism are connected at all?
They have origins in the same, but you'll notice that critical race theory articulates a very particular vision of what the proper structuring is of what could be termed the Marxist view. Marxism structures it absent race. And so the two come together in a very interesting approach. So, for example, Phil Magnus and I argue about this quite a lot because he obviously argues that they're sort of hat in hand together.
Right.
That, in fact, critical race theory is just emergent from Marxism. I think they share some common sort of history in terms of it's intellectual, and there are lots of crossover links. But I think this combination is a fairly unique combination.
Okay.
And Phil's going to come for me later on Twitter because they tell me I'm wrong. It'd be great.
Well,
Phil, don't be too mean.
Well, some of these things as well, it's people that aren't consistent in their philosophical views or in what they've kind of learned. So they sometimes jumble together different things. Maybe it could be that. But there's also the argument that critical theory is kind of connected with critical race theory. Those are different things, but critical theory is really kind of anti-enlightenment and about, who has the most power and who's the most oppressed and that kind of thing.
So at its core, critical theory is a power function game.
Mm-hmm.
That's the root of what critical theory is.
Right.
What critical race theory does, and I do think it's a mistake to use them as synonyms for each other.
Yes.
Because critical race theory takes the premise of critical theory, this power differential question, and then posits that race is the primary power difference, the primary or only power differential, depending on which critical race theorist. The better ones posit it as the major or the most important, not the only, approach to critical theory. And so they emerge from each other, and they are all being developed alongside sort of the Marxist socialist tradition in an era where they're responding to the Enlightenment. So we have a long run of the Enlightenment, and then you have pushback that starts against some of those notions.
So they might kind of overlap then, but
they certainly overlap.
Yeah.
They certainly overlap.
So if we come back to this specific case here on affirmative action,
Yeah.
you think that it will kind of be a middle ground?
So I think affirmative action, I think the court's going to leave us sort of at level 3 of what I've described as affirmative action. I don't think the court's likely to take us back down a level. I also don't think they're going to take us up to this remaking a vision of how the world should look. Mm-hmm. Certainly the court's conservative wing will not take us to level 4. What I think is that the question that is open is, do they pull back on some of what they allowed in terms of that third level of affirmative action? And my expectation is that we'll have a clearer test of what is allowable and what is not allowable. And I think this brings us to an important sort of point, is we oftentimes look to the Supreme Court to resolve social issues, the court never resolves social issues effectively. The court resolves legal issues, and then the social issues have to be dealt with around it. And we're in the middle of those sorts of discussions now, whether it's Hannah Nicole Jones and the 1619 Project or Ron DeSantis in Florida. We're watching that play out. And fundamentally, there are risks from both of those approaches because ultimately they're both political rather than sort of clear-headed examinations of what the world should be, what the world is.
Right, as well. Yeah. I think that there would be some people who would agree with you there. Like the law is meant to do specific things, but as long as you allow it to lean into moral decisions, basically, then you're kind of in trouble because it can swing both ways.
Yeah, I think the only change I would make to that is not moral, political. That ultimately when the law is captured by political things, and fundamentally that's what Ron DeSantis wants, and that's what Hannah Nicole Jones wants, is they want raw political power for their vision of how they think the world should be. When the law is harnessed towards politics, we descend far more quickly to authoritarianism from the right or the left. And the law, in its ideal form, is not political. But we've never had the ideal form of law.
I don't think we've ever had the ideal form of anything.
And we arrive at the sort of sad philosophical question. But fundamentally, the questions that the court has are important ones about affirmative action. And it's telling, I think, that it's going to be a relatively long lead time. I mean, we're recording this in late February. Our case was argued in October. The court is engaged in active back and forth, I'm certain, of memos and discussions about what does the final opinion look like. And my guess is, as I said, we're going to come in at that center area.
Okay, great. Well, I think we've pretty much covered all our bases for this today. Is there anything else you'd like to add, Ryan?
No, I don't think so.
Okay, great. Thanks so much.
Kate.